Hello, everyone. This is Sarah Blakemore. I am the coach of UT Moot Court, and today I'm going to be talking about how moot court ballots are scored. Let's dive into it. So credit for this PowerPoint goes to Danielle Davenport. She was the vice president of moot court at Texas A&M, which is where I started my moot court career. She is one of the best mooters I know. You might be seeing her when we get to scrimmage time. She'll be a justice for us, but thank you to Danny. This is how moot court ballots are scored. So this is an example of a ballot. This is one of Danny and her partner's ballots. You are scored 100 points for each category. There's 4 categories, and your score is a sum of yours and your partner's for a whole round. So the sections are knowledge of the subject matter, responses to questions, forensic skill, and courtroom demeanor, and organization, logic, and clarity. You will also receive little comments right here on the bottom. They usually are not very substantive. So like I said, you are scored out of 400, and you and your partner's score is summed for the ballot score, the ballot total score. These judges are going to give you verbal feedback after the round, after they turn in their ballots, which you should take notes on. That can be really helpful. These sorts of comments are a little bit more substantive than the ones that are written on your ballot. But basically, because the score is out of 800, you have a lot of wiggle room in your scores. Personally, I don't think I ever see scores below 70. I think it's something like judges think that they're grading like at school. It's out of 100, and so it's usually in the range of 70 to 100, which would usually be like failing to passing. So these scores, if you get a 70 on each of them, you have 280 as your score. So because you have all this wiggle room in scores, your partner can do better than you can fumble and your partner can save you, or vice versa. And this is pretty helpful, but also you need to understand that you're not being scored on the case itself, like winning the actual argument. It's presenting the better argument to the justices. In a normal courtroom setting, they don't decide who wins on the day of the case. The lawyers being there is only to answer the questions of the justices that they know is going to be a part of their decision-making process. So basically, it's presenting the better argument rather than winning the argument. So you can have the worst position. One position is always favored in a moot court case, whether you're doing issue 1 or issue 2. You can basically not have a great argument to win over the petitioner or win over the respondent, but you can present a much better flow of an argument, a much better demeanor that justices will like, and you will be scored over the other team. So this first category is knowledge of the subject matter. You have to know the cases. You really have to know the cases. Some justices will just ask you straight up, oh, what's the facts of this case? And you have to just regurgitate a little tagline of what the facts of that case are. You need to know the record. If a justice is talking about something in a question, you need to be able to respond to them with what page number that what they're talking about is on. You need to cite the record in your cases. Basically, this whole thing is about citing the record and about citing the cases. And for extra points, basically you can cite cases in your answers, which is great for our next category, which is responses to questions. So justices will pose questions to you at any time during your 10-minute argument. And some of them are legitimately trying to figure out the case better, and some of them are just trying to grill you. They're really trying to grill you. And you cannot dodge a question. If they get you with a good question, they get you with a good question, and you have to sit there and respectfully answer. You maybe concede a little bit in order to rebut, but you need to answer these questions with deference, starting your answer with your honor, hopefully getting something really clear like yes or no. You want to try to answer yes or no to these questions. And this brings us to our next category, which is forensic skill and courtroom demeanor. This is basically how you look and how you act in the courtroom. When the justices enter the room, you're supposed to rise, you're supposed to stand and stay standing until they're seated. You want to go like shake their hands in the beginning and introduce yourself. They will ask you to introduce yourself. And one partner can say, I am Sarah Blakemore for the petitioner, and my partner is Juliana Stewart for the petitioner issue 2. You will also write your names on some sort of whiteboard or blackboard that's in the room, and make sure to have that handwriting be very clear. Next thing is, honestly, with this demeanor thing, you have to remain really confident. That's what they're looking for. Someone recently said this to me, and I think it fits really well, is you want to have a mind like water. Anytime they ask you a question that's really hard or easy, you just flow through it. You can flow back into your argument after they ask you a question, and you can make the points that you were going to make in the beginning, and not, swaying back and forth or saying a lot of ums, using your hands. Those would all be distractions and detractions to your score for forensic skill and courtroom demeanor. The last category is organization, logic, and clarity. You need to have a roadmap for your argument. A roadmap is basically just an outline when you start your argument, like, may it please the court, Your Honors, I have 2 points, and you say those 2 points. You start saying your argument. They ask you questions, they interrupt you. You still flow back into your argument and say those 2 points. That is exactly what you want to do to get a good score for your organization. You want to be clear and firm. If they get you on a question, you have to, where you can't really answer, you still need to stick to your argument, because you want to be very clear here. Clarity, of course, is what we're looking for. So in this category and the one prior, basically you want to be clear and confident the entire time in order to get good scores. So just like I said before, you want to fake it till you make it. Moot court is honestly kind of nerve-wracking. It's very difficult. You have to know a lot of stuff and be able to think on your feet. And it can be scary sometimes, but the whole point of this is just to prepare you for law school or make you a better speaker. Even if you don't do as well as you think you should have, you have still advanced by giving an argument. You have learned something very great. So have confidence in that, have confidence in yourself for an argument, and you will go far in moot court. So here I am here with a ballot of mine with my old partner, Supriya Sajwani. She is our treasurer now. So this is a round we had against the Air Force Academy. I'm particularly proud of this because the Air Force Academy is really good, and I went up against these people the first year that I did moot court, and I was very nervous and did not do very well, so I got to come back and redeem myself. It was nice and symbolic. Here, you're going to have at least 2 ballots. So here are the 2 ballots. Some justices you will see don't leave any comments at all. And right here, you have the scores at the bottom, which shows who won the round. We lost this ballot on, I think we lost both ballots. Yes, okay, we did. We lost both ballots, but you can see here, there's not a ton of variability between the scores. There are no scores below 90 here. So if justices are just generally impressed, some justices are actual judges, some justices are attorneys, some will be really, really impressed. Some justices are kinder than others. I have found that mooters, people who moot in law school, which are sometimes your justices, are not as generous as the professional lawyers. But some of these judges will even tell you that you're better than the advocates that come into their courtroom. This is actually true. There are some attorneys that just do not have the gift of public speaking. It doesn't really matter. You can still become a lawyer if you are not incredible at public speaking. As you go farther into your moot court education, you will probably listen to argumentations from the Supreme Court. There are recordings of them on OEA, and you will find that some of the attorneys are just really not good at speaking, and that's okay. So here we actually have comments, and yeah, here again, there's no score below 93 this time. It's really kind of not a lot of variability in your scores. So you and your partner can have different scores, and it just comes out of who has more points. Okay, my friends, I hope that was helpful, and I hope you learned something today. So thank you and welcome. Of course, I want to say thank you to our sponsors, which are HooverSlovacek, HaynesBoone, and GreenburgTraurig.